Hello, everyone. Welcome to Court with Krissy. What's more fun than a lawyer getting schooled by a judge? Grandma and Grandpa's Sunday drive, ending with them both in a slammer. I hope you like it. Court with Krissy is now in session.
Good morning, Your Honor. For the record, my call on behalf of the people.
Good morning, Your Honor. Raj Shatari appearing on behalf of the defendant, Ryan VC.
Thank you. And sir, are you Ryan Roderick VC?
That is correct.
Welcome, Mr. VC. Mr. Sudaraya, what time do you have on your clock right now?
I have, Your Honor, 8:59.
What time were you scheduled to be here, and what time did I order you to be here for a hearing today?
I apologize, Your Honor. I was ordered to be here today at 8:45.
Why am I the last to know that you're running almost 15 minutes late for this important hearing?
I apologize, Your Honor.
Well,
I did speak to my client, told him to let the clerk know that I was running a little bit late just due to traffic.
well, Mr. VC, or excuse me, Mr. Sudaraya, you can probably expect that as a trial court judge that handles 3 different counties in the 46th Circuit, I have a busy schedule. This case, your case, is not the only matter that I have going. You can probably understand that, right?
I do understand that, Your Honor, and I apologize.
So I set aside specific time for this matter early on my docket because last time we tried to join, Mr. VC was present. The court wasn't able to get back connected because I had problems with my recording system. I'm not trying to be overly difficult, Mr. Sudaraya, but if it comes to be, again, that you're running late or have issues, the first thing you should do is contact my court staff so that I can try to reach out to the other people and make accommodations. Is that clear?
Understood, Your Honor.
All right. Mr. VC, I know that last month or last week on Tuesday, you were present, at least in my waiting room. What happened is I told this to your attorney and to the prosecutor, but you weren't able to be present. I had issues with my recording system. That has really never happened as far as I recall since I've been on the bench, but it happened on the day, so I was almost an hour behind. So I told your attorney that I would be willing to call your case later, but he also had some other matters going on. But that's why I adjourned, and I said I would get another hearing date on. Are you now aware of that background, Mr. VC?
Yes, I am aware of that. Thank you.
So the other background is, of course, that we have a trial set for your benefit because you asked for it coming up next week on July 16th and 17th. So as I told you, what I was going to do is then set this matter for 2 things. One is a final status conference. That's for the attorneys and I to talk about trial preparations. And the other is for what I call a plea cutoff. It just means this is the last opportunity you can take a plea if you want to. If you don't want to, we'll simply have the jury determine all of the issues, but this is the last date that I would consider any pleas. Are you aware of all of that background?
Yes, I am, Your Honor.
And have you had enough time to talk with your attorney about all of that background?
Yes, I have.
Mr. Sudaraya, how should the court be proceeding with regard to status conference?
Your Honor, if I could be put in a breakout room with counsel for maybe one last discussion.
No, you can't. Again, I just told you, we're already 15 minutes late. I have other parties and other attorneys waiting for a matter which is also scheduled to start at 9 o'clock, and it can't start at 9 because you were 10 minutes late or 15 minutes late. So I don't have the ability to do that. I've got other matters that are just as important as this one is.
That's fine, Your Honor. Then I suggest that we proceed with the scheduled trial date, if that's still a good date and time.
It is a good date and time. Mr. Ola, are you ready to proceed to trial on July 16th and 17th?
Yes, Your Honor.
On behalf of the defense, Mr. Sudaraya, I don't have criminal jury instructions from you. I'm going to take you back in time to all the way when this case was bound over. You got an order following bind over that ordered you to appear and Mr. VC to appear for a first status conference, correct?
Correct, Your Honor.
That order provided a bunch of different things, including that you file full text jury instructions at least 14 days before trial, correct?
Correct, Your Honor.
We're now 4 days before trial. Why have you not filed full text jury instructions at least 10 days ago?
Your Honor, honestly, this case is fairly old, and honestly, it just slipped my schedule. I just received the jury instructions and a witness list from the prosecutor yesterday at about 3:30 in the afternoon. So that was sort of my reminder. I assumed that I honestly didn't recall that we didn't get that done. I mean, this case is over a year old, Your Honor.
Mr. Ola, why is it that you filed jury instructions for a case that's this old, given the fact that you know that I require jury instructions at least 14 days before trial?
And Judge, I'm glad you gave me the opportunity to respond to that. First off, what was sent to defense counsel yesterday was an amended witness list. The original witness list was provided to them back in May, I believe. As far as the jury instructions, and again, I'm responsible for my office. The information I had is that the same person who originally filed the witness list had done the other instructions. As soon as I found out after getting back from our trial yesterday that that was not the case, when I checked on it, I immediately had filed them with the court, the jury instructions, and voir dire for this matter, send out copies of that and the amended witness list to defense counsel.
Counsel, there should not have to be reminders from the court about time. There should not have to be reminders by the court about the requirement for jury instructions. The jury instructions are for the benefit of the parties. Therefore, the use by the parties, and they require that I instruct the jury about important issues that affect Mr. Vesey. I shouldn't have to be asking for jury instructions from anybody. But I do have to. And so what I'm going to indicate is I've got prosecutors' jury instructions. Those are going to be what I read. I might take into account what you file if you file it today, counsel, in terms of any request to have additional jury instructions or clarifications. But ultimately, this process, arriving late, not having things filed, is not a good look. And I'm not willing to extend time periods. If you have jury instructions filed by the end of the day today, Mr. Sudaraya, then I'll consider them. If you don't, I won't. I'm also going to simply indicate this. I'm going to start my other hearing. I've got that other hearing with other attorneys and other parties that are ready. The attorneys are feel free to discuss. And if there's something that you discuss that means you need to discuss with me, you need to get on the phone immediately with my staff and find out if this morning yet I can come back on the record in this case. I don't know whether or not I'll be able to or not. But that will give you the time in reverse order, Mr. Sudaraya, that you asked for that I'm not going to provide right now. In other words, if you want to talk with Mr. Rolla and that reveals something that I need to hear about, you need to both be available. You need to both come back on and you need to be able to tell me that. Mr. VC, for right now, your trial is going to start on July 16th, 4 days from today. You need to be present no later than 8:30 in the morning of trial. Do you have any questions so far, Mr. VC?
I do not.
You also need to be aware that if your attorney is going to join me again in the future today, you're going to be required to join as well. So that means be in contact with your attorney. If there's a need for you and him and the prosecutor to be back on this hearing room later, you're going to be required to be present along with your attorney. You understand?
Yes, I do.
All right, then the court is in recess for now. If I don't see you later this morning, everyone, then I will see you on the morning of trial on July 16th and then the morning of trial on July 17th. Thank you.
Your Honor,
Thank you, Your Honor.
Thanks, Your Honor.
Can I indicate to defense counsel, I'm going to be in the office all day today if he wants to try and reach me by phone, and he will be able to get in touch with me should he need to.
Thank you.
Thank you.
Thank you.
We're all set.
You ready, Judge?
All set whenever you are, yes.
Stand right in front.
Hi there, can
State
you,
your full name.
Catherine Ann Schaefer.
Ms. Schaefer? All right, you still live on Bonita Street?
Yes, sir.
And confirming that is space number, give me a moment. All right, and do you have an email address?
Yes, sir.
Can I get that, please?
41 at Gmail.
CASE7541 @gmail.
Yes.
All right, thank you. Your phone number ends in 9571.
Yes.
Okay. The state's alleging 3 charges against you. One of them is a misdemeanor charge. 2 of them are felony charges. First, the misdemeanor charge. That is failure to remain at an accident scene involving damaged property. That's a Class 2 misdemeanor. The 2 felony charges are narcotic drug possession or use, and the second one is drug paraphernalia possession or use. On all of those charges, you have the right to remain silent, right to counsel, and right to trial. I scheduled you for a arraignment on the misdemeanor charge on the 31st of July at 9 o'clock in the morning.
Okay.
The arraignment.
And I get to go home?
You're talking on page 12 when I'm on page 2. So
Okay.
we're nowhere near talking about that yet. So
I'm sorry.
don't even think about whether you're getting out or not. Listen to what I'm saying instead.
Yes, sir.
Okay?
Yes, sir.
So the arraignment that is scheduled for July 31st is where you'll need to be prepared to plead either guilty, not guilty, or no contest. Depending on how you plead will be what happens next with the court proceedings, okay?
Yes, sir.
Your release conditions are as follows on the misdemeanor charge. Obey all orders of the court. Do not commit any crimes. Notify the court if your address changes. Do not leave the state of Arizona without permission of the court. Do not have any contact with the alleged victim in any manner. That's on the misdemeanor charge. Now, regarding your felony charge, now you asked about getting out. So on the misdemeanor charge violation, I'm releasing you on your own recognizance. You're not remaining in custody on the misdemeanor charge. Now we're going to talk about the felony charges. Okay, I've scheduled you for a preliminary hearing on the 22nd of July. Okay, that's at 4 o'clock p.m. The preliminary hearing is where a prosecutor or a state representative will present testimony and evidence to a judge or to a grand jury to determine if there's probable cause to charge you with those felonies. If there is probable cause, your case will be bound over to the Gila County Superior Court. If there's not probable cause, the 2 felony charges will be dismissed and that'll conclude it. Your release conditions on those 2 charges are obey all orders of the court, not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not possess, consume any alcohol or drugs without a valid prescription, and do not possess any firearms. It's a felony allegation. On those felony charges, I am placing a $1,500 bond on you. So you'll remain in custody unless you, hold on. You'll remain in custody unless you post that bond. Or what will happen is, since you're remaining in custody, the county attorney is required to file a formal complaint against you within 48 hours of the date and time of this hearing. If they don't file the formal complaint, you'll be released on your own recognizance. If they do file the complaint, then you'll have the potential to have a court-appointed attorney appointed to your case, and they'll review the bond. You have a question?
I do. I, with all due respect, Your Honor, I have some reasons why I should be able to go home. I have no money. I have, my husband is disabled and elderly, and the state pays me to take care of him.
Is that the co-defendant?
Yeah.
Okay, well, we've got, he's in custody also, so you don't have to do that.
Yeah, but he has fewer charges than me, so I
Okay, well, you won't have to worry about that as of now. Okay, so
I have a little cat, and I have absolutely no one to take care of her.
Okay, so, ma'am, those are not going to be valid reasons that you're being released, and here's why. Here, hold on. You're still wanting to talk. Hold on. You have a substantial criminal history with failure to appear on your record. These charges are felony charges, so we can't have that happen on these charges. So that's number one, okay? The second portion of that is, since you're in custody, I have to ask you some questions regarding your finances to see if you qualify for the court-appointed attorney. So if that complaint is filed within the 48 hours, your attorney can look to see on a bond review for you, okay? So I need to ask you questions on that financial statement.
I have been planning to go as far as the fentanyl to treatment next week.
Well, that's great, but it's it's a week too late, because here you are with the allegations of these charges against you. So it's not going to change the bond right now, all right? Let me ask you some questions regarding your finances. Please raise your right hand. I need to administer an oath. I got to be able to see your hand. Thank you. Do you solemnly swear the information you're providing the court regarding your finances to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
What is your marital status? Single, married, partnered, separated, or divorced?
I'm married.
Okay. How many other people do you financially support?
None.
Okay. Do you have a job?
Yes.
Okay, what do you do?
I take care of my husband.
What does that pay you?
Minimum wage for 14 hours a week.
Okay, and so what is your approximate monthly take-home pay? How much do you get paid per week or every other week?
Every other week I get $300. About
Okay,
$300.
so roughly $600 a month.
Yeah.
Okay. Do you have income from any other sources like Social Security, food stamps, investments, disability, or unemployment?
My husband's Social Security.
Okay. How much is that income?
1,100.
Any other sources of income of those benefit programs? Do you own a house?
No.
Do you have any bank or retirement accounts?
No. Oh, bank account.
Okay. It's a regular checking account.
Yes.
What is the balance in the account, roughly?
About $1.
$1?
Mm-hmm.
Okay. Do you have any outstanding loans?
Our storage unit.
Now, is that an expense or a loan?
It's an expense.
Okay, so we'll get to that here in a moment. Do you have any loans?
No.
Okay. All right, so the total amount of all of your monthly expenses, not just your storage unit, but anything else you pay on a cell phone, electric bill, or anything, what do you think that monthly average is?
At least 1,000.
Okay. Okay, the court finds with the financial information you provided the court that you do qualify for a court-appointed attorney. So I'll send this report to the Office of Indigent Legal Services, and what will happen is if that complaint is filed within 48 hours, they'll assign the attorney to your case at that time. If the complaint is not filed within 48 hours, then the case is not filed, but they can file it up to 7 years from the date of your arrest, okay? At that time, if they do file it, then we can review this information again about the appointed attorney. Do you understand that?
I do. I'm really needing to go home. I can't stay here. There's a couple things about the jail that I want to share.
Well, I don't. You might want to share those with the detention staff.
All
Okay.
right.
So if you have complaints or any of the things that are taking place on at the jail, make sure you tell the detention staff regarding that. And but otherwise, the bond remains in place. You're released on the misdemeanor.
I don't have that kind of money. I don't have that money, and I don't have family. I have no family.
I understand. So what will happen is you'll remain in custody until your next court date, or if they don't file that complaint in 48 hours. Okay? That'll be all, ma'am. Have a good day.
K9's outside of 5. Okay, forward, forward. Forward. Okay, go and state your full name.
Michael Eugene Schaefer.
All right, Mr. Schaefer. Is your address still number 26 on Bonita Street?
Yes, sir.
All right, sir. And then do you have an email address?
I'm not right now.
Your phone number ends in 9571.
Yes, sir.
Have a seat.
Okay. The state is alleging 3 charges against you. One of them is a misdemeanor and 2 of them are felonies. The first charge is driving with a suspended, revoked, or canceled driver's license. And then the 2 felony charges are narcotic drug possession or use and drug paraphernalia possession or use. On those charges, you have the right to remain silent, right to counsel, and right to trial. I've scheduled you for, on the felonies, a preliminary hearing on 7/22 of 2024 at 4:00 p.m. A preliminary hearing is where the prosecutor or state representative will present testimony and evidence to a judge or to a grand jury to determine if there's probable cause to charge you with those crimes. If there is probable cause, your case will be bound over to the Gila County Superior Court. If there's not probable cause, the felony portion will be dismissed. Your release condition on the felonies are obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not possess or consume any alcohol or drugs without a valid prescription, do not possess any firearms, because these are felony charges. If you're convicted, you could become a prohibited possessor. Now, you are on release conditions from a prior case out of the Superior Court. Being that you're held, that you're charged alleged crimes or felonies, that means you're not eligible for a bond, so you'll remain in custody until you see the Superior Court judge on these charges. Do you understand that?
Yes.
All right, sir. Now, you may qualify for a court-appointed attorney. I need to ask you some questions about your finances. If you could please raise your right hand. Do you solemnly swear the information you're giving regarding your finances to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. What is your marital status? Single, married, partnered, separated, or divorced?
I'm married.
All right. You can go ahead and lower your hand down. How many other people do you financially support?
None.
Okay. Do you have a job?
No. I'm retired.
Okay. Do you receive any income from Social Security, disability, unemployment, child or spousal support, or any other investments?
Okay.
How much Social Security do you receive?
1200.
Do you own a house?
No.
Do you have any bank or retirement accounts?
No.
Do you have any loans?
No.
Do you know what your monthly expenses are? At the end of the month, you have $1,200. How much extra do you have left after you pay all your bills?
None.
Okay. The court finds that you do qualify for a court-appointed attorney, so let me explain to you how that works. Is the county attorney has 48 hours to file a formal complaint against you on these felony charges since you're remaining in custody. If they do not file that complaint within 48 hours, you'll be released on your own recognizance and not have a bond. If they do file the complaint within 48 hours, which does not count weekends or holidays, if they do file that complaint, then the attorney will be assigned to you at that point. This information will be sent over to Indigent Legal Services for you, and they'll be ready to assign the attorney if a complaint's filed. You understand that?
Yes, sir.
All right. Now, sir, we're going to talk to you about the misdemeanor charge that's held against you. That's the driving on a suspended, revoked driver's license.
All right.
That's a Class 1 misdemeanor that has a maximum fine of $2,500, 6 months in jail, and or 3 years of probation. There is no mandatory minimum, so the court's discretion is 0 up to the top of that, what I just explained to you. Your options are to plead guilty, not guilty, or no contest. If you plead guilty or no contest, we can prepare sentencing paperwork for you now and get it sent over and get the case resolved of. If you plead not guilty, we'll schedule you for a pre-trial conference. That's where you'll meet with the prosecutor on the misdemeanor charge only, discuss the case, and one of 3 things would happen with the driving suspended violation. Number 1, the case could go to trial. Number 2, the case could enter a plea agreement that all parties agree on. Or number 3, it could be dismissed. You also have the right to an attorney regarding the misdemeanor. The misdemeanor case does not qualify for a court-appointed attorney, as there's no jail time being asked of you for that charge. Do you understand? Okay. How do you wish to plead to the charge?
If I plead guilty, will it be a fine?
It'll just be a fine, correct?
I'll plead guilty to the charge.
All right, sir. All right, sir, I need to have you acknowledge some facts and circumstances here real quick, and then also make sure that you're aware of the rights that you're giving up by pleading guilty. Number 1, you have to agree to have this video appearance instead of an in-person appearance. Do you consent to that?
Yeah.
All right, and you're also consenting that you wish to plead guilty and not have the presence of an attorney, correct?
Yes, sir.
Okay. I'll be sending you a paper that is a waiver form that talks about the video appearance and you waiving your right to an attorney. All right, so the rights that you're giving up by pleading guilty is the following. You're giving up the right to plead not guilty and have the state have to prove your guilt beyond a reasonable doubt. You're also giving up the right to have a trial in front of a judge. You're giving up the right to have the assistance of an attorney at all stages of the proceeding, and we're going to send you that attorney waiver form that you've indicated you don't want an attorney. You're giving up the right to confront witnesses and to cross-examine them as to the truthfulness of their testimony. You're giving up the right to present evidence in your own behalf and have the court subpoena witnesses in favor of your case free of charge to you. You're giving up the right to remain silent and to be presumed innocent until proven guilty beyond a reasonable doubt, and also giving up the right to a direct appeal. Are you on probation or parole?
No.
Okay. Every person that pleads guilty, is found guilty, or pleads no contest has read the following citizen's advisory. If you are not a citizen of the United States, pleading guilty or no contest to a crime may affect your immigration status. Admitting guilt may result in deportation, even if the charge is later dismissed. Your plea or admission of guilt could result in your deportation, or could prevent you from ever being able to get legal status in the United States, or prevent you from becoming a United States citizen. Knowing these rights I've explained to you, you wish to give them up and enter your guilty plea?
That's good.
Okay. All right, sir. So it indicates, per the report, that on July 9th of 2024 at about 1:56 p.m. you were contacted at or near the 200 block of West Benita Street by the Payson Police Department. In that investigation, it was found that your driver's license was suspended, revoked, or canceled. You were issued a citation and booked for that violation, and you are appearing today pleading guilty to that. That offense occurred in the city limits of Payson in the county of Gila, which is in the jurisdiction of this court. Is that accurate?
Yes.
Okay. Sir, regarding your plea, you've made that voluntarily?
Yes.
Nobody promised you anything, and to make a plea you'd receive a lighter sentence?
No.
Anybody force, threaten, or harass you to enter that plea?
No.
All right. Court will accept your plea and finds that you've made it knowingly, voluntarily, and intelligently. We'll have paperwork for you to sign regarding waiving those rights. Sir, do you wish to give a statement regarding driving suspended only before I impose the sentencing on the case?
No.
All right. The standard fine is $441. Do you need to go onto a payment plan regarding that, sir?
I suppose I do.
Okay. There's a one-time jail fee of $69, so the $441 plus $69 comes out to $510. How much can you afford to pay on that per month, sir?
I have no idea. Only $50. If I ever get out, I'm at the end here forever. So.
Okay, what I'm going to do, sir, is I'll put you at the court minimum of $25 per month. and I'm going to suspend that payment for a couple of months. That way you kind of know what happens with the other case, all right?
Okay.
First payment will be due on September 13th.
All right.
All right, sir. Also, you have the right to file a Rule 33 petition for post-conviction relief, and if denied, file a petition for review. I'm going to give you a paper that explains that. It'll also explain to you how to request to set aside the judgment of conviction pursuant to Arizona Revised Statutes 13905, and how to request a certificate of second chance pursuant to Arizona Revised Statutes 13911 once the terms of the sentence and time frames therein have been satisfied. So you'll have a paper that'll explain that to you too. All right, I'll get this paperwork sent over to you so you'll have some documents to sign, and then we'll proceed forward from there. Do you have any questions at all, sir?
No.
Okay, that'll be all then. You have a good day.
Sure, I can try to stand up. Oh, God. This way. Okay, Judge.
All right, I'll probably send it to you since there's a lot in that defendant there as one, and then I'll send all the others in the other one.
That's fine. All right,
Okay.
thank you, sir.
You bet. Have a good one.